Hello, this is Matt on the Moon Lambeau channel. Today, the court released a transcript which up to this point had been kept secret, having to do with two highly consequential topics that the judges need to rule on, including the DPP, I'm sure you've heard that term at this point, deliberative process privilege, which is this idea that the SEC has, which is rather fanciful, that basically everything that they've ever said having to do with Ethereum and Bitcoin and XRP or crypto in general, it's privileged and they don't have to share it with anybody. It's theirs. And, given that they're the SEC and they seem to think that they are some sort of deity to be praised, they don't have to share a damn thing. That's effectively their position. And then there's also Ripple's fair notice defense. This idea that Ripple should have known that what they were doing was illegal in the eyes of the SEC. No, there's no way they could have, because even the SEC clearly didn't know whether or not the XRP itself was a security. It seems pretty obvious. And so here's the thing about this. These documents having to do with Bitcoin and Ethereum and XRP, this is the reason this part is so consequential. If they're privileged, and it can't be used as part of a broader point for the defense, which weakens the fair notice defense if the court even allows that to stand. So there's a lot of moving parts, obviously. But this transcript that was released, I just finished reading it before recording this latest Moon Lambeau Hot Jam, 42 pages. And I highlighted a couple parts that I found to be particularly interesting, which I'll be sharing with you. So this transcript comes from a telephonic conference, and it was one of the ones where you could have actually dialed in. There's a limited number of seats, if you will. I think it was up to 4,000 ultimately, and the lines were maxed out. But it's good to see this getting out here. And so all of this led to this headline from Finance Feeds. XRP lawsuit, make or break, ruling for Ripple ahead. Conference transcript release. So plenty to talk about here, but before going further, I do want to be clear that I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Now, they start by stating the following, which I find interesting. Check this out. The release of the transcript might signal that the judge's ruling over Ripple's motion to compel the SEC to hand over internal deliberations is right around the corner. This motion is a make or break for Ripple's fair notice defense. That's what they're positing. The fact that the transcript is released right now might signal that a decision from the court, from the judge, is imminent, but that's actually not the case. Take a look at this, and I can prove it. Here's a tweet from XRP community member James K. Filan, who is, of course, an attorney, and he's all over posting the most recent legal filings all up on the Twitters, which I'm endlessly appreciative for, and I know others in the community are as well, of course. And here you can see he tweeted out this, transcript released. Below is the transcript from the August 31st, 2021 conference regarding the deliberative process privilege. And then he wrote nothing else to report at this time. And then somebody within the community named Rich wrote, thanks for this. Could this be requested for the DPP decision? The judge wanting to go over specific arguments made before a ruling? ? And then somebody named Fred jumped in and wrote, an August 31st, 2021 transcript of a discovery battle begun in May 2021 or earlier that was re-argued last month. The only speculation I would make is that the court is ready to issue a ruling finally and did some housekeeping and realized the transcript was not posted. And so there you go. Here, this individual within the community, Fred, also speculating a little bit, which is fine, speculating that perhaps the reason this is released is because the court is ready to issue a ruling. But it turns out that's not the case. In fact, we wouldn't even have this document today if not for attorney James Filan. Check this out. He wrote this. There are rules about when a transcript can be released to the public, and date for this transcript was December 28th, 2021. When I checked the docket today and saw it wasn't released, I called the court reporter and they released it. It was an oversight due to the holidays. So how about that? An XRP community member who, of course, is an attorney here, James K. Filan. If not for him, the court wouldn't have released this like they were supposed to. How about that? How about an attaboy for James Filan? I thought that was pretty cool, so I decided to share it with you. So now into this. I'm going to jump to page 11 here. I guess I can scroll down a little bit for you folks that are looking at your screens here. Here we go. And so here's a point where Ripple's attorney, Matthew Solomon, begins to speak. And what he says here, it's just like, this is why the SEC documents are so crucial, because I'm telling you, there's a chance that this could absolutely clinch this case for Ripple. It could, these documents, depending on what's in them, could result in a solid win for Ripple. Do we really think that all these years that the SEC has been speaking behind closed doors, do we really think that they never, amongst one another, posited the question or stated something to the effect of, I'm not sure what to make of XRP? Not once, not ever. Because if that exists, they're going to have a hard time arguing that Ripple should have known what they were doing was illegal when they themselves didn't know. That's why this is so highly consequential. So here is what attorney Matthew Solomon, Ripple's attorney, had to say. One of Ripple's many attorneys. These documents, we believe, will be highly, highly exculpatory because it wasn't so obvious to the SEC that XRP was a security. And this is where Judge Netburn jumps in and says, let me switch gears now and ask you some questions about the deliberative process privilege, or DPP for short. In reading the SEC's opposition, they seem to make the argument that the deliberative process privilege doesn't need, I think this is the argument they make, doesn't need a specific decision. That you can be pre-deliberative, but you don't necessarily need to identify specifically what the decision that was being deliberated is. And so, I wanted to get your read on whether or not you believe that the deliberative process privilege requires that the court find the decision in order to determine what is pre-decisional, or whether or not there is case law that supports the proposition that an entity can be sort of in perpetual deliberation. And so to be clear here, before reading further, the judge is talking about the SEC's argument, which effectively, in part, is that, in terms of, and they actually, well, I don't want to get ahead of myself. I guess I can mention it here. The SEC attorney, Jorge Tenrero, he actually ceded an important point to Team Ripple. And in addition to that, never provided specific information as to when this deliberative process began and ended, or what a reasonable time frame might be, which is actually highly consequential, because what the judge clearly is getting at here is this idea of, okay, can you just eternally be in perpetual deliberation, which obviously, and this is the reason this is important, can you be in perpetual deliberation, which of course would shield you from having to share highly consequential information? Can you just say, nope, we're always in deliberation and then everything's a secret? Because that doesn't seem right. That doesn't seem fair, right? And so that's what the judge is trying to get at. And so here is what attorney Matthew Solomon had to say. I think that an agency cannot be in a perpetual state of deliberation. I haven't seen a single case, Your Honor, where any court has accepted the kind of breathtakingly expansive claim of deliberative process that's being made here. And basically, I think Mr. Tenrero, again, that's the SEC attorney, Mr. Tenrero will tell you this straight up. As he articulated to us several times, they're taking the position that going back to 2013 and continuing through today, the SEC has continuously deliberated on the issue of whether, not just Ethereum, but also Bitcoin, and I guess concluding at least in December 2020 for some sales purposes, XRP are securities. That's their position. They were deliberating back in 2013. That continued in the ensuing 8 years, and it still continues today. I think Mr. Tenrero cited that in his opposition, that some courts don't require there to be a specific identifiable policy that was actually enacted. But what courts do require, and this is important, what courts do require is that for each document that is allegedly part of a deliberative process, that the document needs to be tied to an actual process that has to be articulated, and the document has to be prepared in order to assist the decision maker in arriving at an actual or potential decision. And that's what's missing here. I think what the SEC is trying to say is it's all one big, long deliberation, but we're only going to give you platitudes. Matthew Solomon knocking it out of the park here, absolutely. And this indeed is the case. He's spot on here. Here's the thing. Even setting aside, lack of timeline here, or like a beginning point, like specific, even just that. Even if you set aside all of that, this isn't tied to any sort of actual process, and so given that's the case, or at least they certainly hadn't proved it to this point. So given that's the case, how the hell can they claim privilege over this and keep all this information secret? And that doesn't make sense. And so then later, and I'll just tell you this too. Later on this call, the judge was pushing attorney Tenrero to answer the same question that she ended up posing, that she had posed here to attorney Solomon, and he was stuck, and he ended up admitting that the SEC is not entitled to perpetual deliberation. He actually ceded that point. You can't just forever say, we're still thinking about it. We don't have to share anything because we're still thinking about it. We may or may not ever change that stance. He ceded that you can't do that. He gave it up. But here's the thing. He refused to give a start/end point for the details of this case specifically. How the hell can you do that? It's like he's giving up the point because he had to, because he didn't have an answer for that, but then also being kind of like, yeah, we still want to do it though, by refusing to provide a start or end point. It's like offensively stupid is what it is. That seriously, folks, this is ridiculous. And then there's this here. Oh, and this is, okay, I want to share with you just a few sentences from what the judge said later on the call. And this actually is what ended up happening. She says what she was thinking about doing, and this ultimately is what came to pass. We're just waiting to find out what the decision on this will be, but she said the following. This is Judge Netburn here. My inclination is to conduct an in-camera review. My inclination is to do what I always do in these cases, which is to request that the party seeking the documents identify a small number of documents, which the defendants have now done, and then ask for limited briefing, recognizing that the SEC has a privileged position because I'd like them to explain to me, potentially with some of that information redacted, to the defendants, why they believe the privilege applies. And so that's what's happened. And so the judge ended up getting access to whatever quantity of documents. I'm not privy to that information, none of us are. But these internal documents having to do with Bitcoin, Ethereum, and XRP that the SEC doesn't want out, the judge is getting to see all of this. And so I'm speculating that the SEC's position is complete BS and that there's stuff in there which is very incriminating, which is why they're fighting so hard to keep it secret. Because think about this. If it's so clear that XRP has always been a security, then they would have said that behind closed doors. And if that's what they were saying behind closed doors, it would be in their interest to have this shared in the case because it would destroy, not destroy, but harm, certainly, Ripple's fair notice defense. If they knew, if that's proof, if there actually were proof that the SEC had always thought that XRP were a security, they'd want that. But instead, they want this information hidden. So I'm speculating that there's something in here damaging, and that's why they're hiding it. There's something that would help Ripple's case. Perhaps supreme uncertainty surrounding XRP's legal status. Perhaps that's what it is. And again, it's just speculation, but I think it's pretty reasonable speculation, is it not? So what the judge did is ended up taking whatever the quantity of documents was on these topics, and she's reviewing them, or at this point probably has reviewed all of them for herself, and then will determine, based on that, whether or not the SEC's claims of privilege are reasonable and should stand. And I'm telling you, if there's stuff that's highly consequential, I don't suppose that the judge is going to say, no, this isn't relevant. I especially considering that this hasn't been tied to any sort of specific deliberative process. They haven't been able, the SEC attorneys, they haven't articulated anything along those lines, which is what attorney Matthew Solomon pointed out. So even from that perspective, none of this deserves to be kept secret forever, but that's what they're trying to do because they are asshats. That's if you're wondering the reason, they're asshats. That's it. Just no need to question further. That seriously is it. So we're going to find out soon what's going down here, because again, a couple calls to be made here. And so here's XRP community member Stefan Huber, who wrote, "Dear John Deaton and dear attorney Jeremy Hogan, am I correct in thinking that Judge Nepern has to issue the ruling on DPP and the SEC's motion to strike the fair notice defense before end of expert discovery on Wednesday, January 19th? Thanks." And attorney Jeremy Hogan did jump in here and wrote, "The deadlines only really apply to the parties, but yes, Judge Nepern needs to issue a ruling on the DPP issues before the 19th. The motion to strike the fair notice defense will be ruled on by Judge Torres and will likely happen after the 19th, as it's not a part of discovery." And then he noted in a separate tweet, which is on your screen, that he thinks that will be in February-ish. So who knows? Maybe that could even happen a little bit sooner, perhaps this month, January. That's the big one. Well, they're both big, but in particular, Ripple's fair notice defense, I'm super curious about that one. And I don't see how that couldn't go in Ripple's favor. I think any neutral observer that comes in and just hears the facts, and they're a blank slate to begin with, if you just look at it, and all of the messiness and all the uncertainty in the space, which any participant in this space will tell you, there's just not certainty. Once you learn all these facts, I don't think an unbiased person could come to any other reasonable conclusion. So I'm optimistic, somewhat cautiously, just in case, but I think this, logically, it should be in favor of Ripple. It should be good. And some of these documents regarding DPP, I sure as hell hope that they ended up being found to be something that should be included for the defense as evidence. I would certainly hope so, but we'll see. Who the hell knows what's in there? Just the judge and the SEC asshats. So we'll see here. But yeah, we're gonna get answers on a couple really big things really soon, as it turns out, and I very much look forward to that. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.